The presentation of evidence is very important for any trial. Evidence includes Crown evidence, defense evidence, witnesses, rules of evidence, and self-incrimination. Since the burden of proof is on the Crown, it is responsible for presenting evidence against the accused. It could be direct evidence, usually based on witnesses' testimony, or circumstantial evidence, indirect evidence that tries to link the accused to the crime through circumstance and physical evidence. The main responsibility of the defense is not to present evidence, but to raise reasonable doubt. If the defense believes that the Crown has not presented its case effectively, the defense may request a directed verdict, that is, asking the judge to dismiss the charges on the basis that the Crown has not adequately proven its case. If the defense decides to present its own evidence, it is usually in the form of witnesses. Everything else is meant to counter the evidence that the Crown presents. There are several types of questions that a lawyer may present. Examination in chief. These are the questions a lawyer asks his or her own witness in court, also known as direct examination. Leading questions are not allowed during this examination. A leading question is a question that already contains or leads the witness to the desired response. Cross-examination are the questions a lawyer asks a witness called by the opposing side. Although most witnesses appear in court voluntarily, they may be served with a subpoena, that is, a court document that orders a person to appear in court. If a subpoenaed witness refuses to appear in court, he or she may be fined or imprisoned for up to 90 days. Witnesses are often excluded from a courtroom until it is their turn to testify, so that they are not influenced by what they are watching. A witness who knowingly gives false evidence may be guilty of perjury and could go to prison for up to 14 years. All of the rules on the admissibility of evidence are contained in the Canadian Evidence Act. If the admissibility of evidence is questioned, the judge may order a voir dire, known as a hearing within a hearing, to decide if the evidence should be allowed. If a voir dire is held, the jury is ordered out of the courtroom until the hearing on the evidence is finished. The jury returns and the trial continues. The Charter of Rights and Freedoms protects witnesses from incriminating themselves while providing testimony during a trial. If a witness believes that they are being asked questions which could incriminate or implicate them in a crime, they may object to the question. The only exception is perjury. If law enforcement officials believe a witness is guilty of a crime based on the answers he or she provides during his testimony, they may lay a charge on that witness as soon as he or she steps out of the courtroom. The common types of evidence introduced during a trial include privileged communications, similar fact evidence, hearsay evidence, opinion evidence, character evidence, photographs, electronic and video evidence, polygraph evidence, and confessions. Any communication that is considered confidential is privileged and cannot be used in court. For example, lawyers' clients, doctors' patients, spouses, religious officials who have heard confessions. The person who receives the communication is the dominant party. If he or she decides to present confidential information, it will have no force as it is an abuse of his or her position. Similar fact shows the accused has committed similar offenses in the past. It is meant to establish a pattern of behavior, sometimes called the similar fact rule. Hearsay is evidence that is repeated by a third party, not coming from the direct experience or knowledge of the witness. For example, repeating something he or she heard someone else say. Opinion is evidence based on the observation of an expert who may be paid for the testimony. Expert testimony must be relevant to the case. Character information is information about what kind of person the accused is, indicating the likelihood of their committing a crime. The defense may introduce this type of evidence to generate sympathy for its client, but this also allows the Crown to question the accused character. Photographs may be entered as evidence if they are proven to be an accurate portrait of the crime scene. A judge may exclude photographs if they are simply meant to inflame the jury. Surveillance includes cameras and other electronic devices used to intercept private conversations. Surveillance devices must be authorized by a court order. A polygraph or lie detector test measures changes in a person's blood pressure and pulse rate when he or she is asked questions. The Supreme Court has ruled that polygraphs are not entirely reliable and therefore are not allowed to be introduced in court as evidence. Police still use them as an investigative tool. A confession occurs when the accused person admits that he or she is guilty of a crime. For a confession to be considered in court, it must be provided voluntarily by the accused. After all witnesses have been called, the Crown and defense each present a summation or closing statement. This is a summary of each side's arguments and evidence. After summations, the judge makes the charge to the jury. In it, the judge reviews the facts and defines and explains the law that applies to the case for the jury. A judge can also indicate to the jury how the evidence should be weighed. After this, the Crown and defense can challenge the charge for legal errors. Many appeals result from the judge's charge to the jury.